I'll read and deal with the issues of irregularities and illegalities. And the issue we were dealing with is whether there were irregularities and illegalities committed in the conduct of the 2017 presidential election. And if the answer is in the affirmative, what was their impact, if any, on the integrity of the elections? While the impaneled election was conducted in violation of the relevant constitutional principles, the same was also alleged to have been fraught with irregularities and illegalities that rendered the result unverifiable and thus indeterminate. Illegalities refer to breach of the substance of specific law, while irregularities denote violation of specific regulations and administrative arrangements put in place. The petitioners, in that context, claim that the 8th August 2017 presidential election was conducted in an environment characterized by many systematic and systemic irregularities and illegalities that fundamentally compromised the integrity of the election, contrary to the principles laid down in the Constitution. The alleged irregularities and illegalities ranged from blatant non-compliance with the law to infractions of procedure, some of which were requirements by the laws and regulations relating to the election, while others had been put in place by the first respondent for the management of the elections. Illegalities. Allegations of undue influence, bribery, and voter intimidation. In addressing the above issue, at paragraph 37 of his supporting affidavit, Raila Odinga deposits that the third respondent, President Uhuru Kenyatta, brazenly violated Section 14 of the Elections Act. He must have meant Section 14 of the Elections Offences Act by inadvertently and by advertising and publishing in the print and electronic media as well as on billboards achievements of his government contrary to that section. We have quoted the section, I don't have to read it. This prohibition is clearly what Article 81E2 refers to as improper influence. In our view, the rationale behind this prohibition in the context of this case is that whatever achievements the current government may have made resulting from expenditure of public funds should not be taken advantage of by the government as a campaign tool. Section 14(1) and subsection 2 of the Elections Offences Act provide that except as authorized under this act or any other written law, a candidate referendum committee or other person shall not use public resources for the purposes of campaigning during an election or a referendum. Subsection 2, no government shall publish any advertisements or achievements of respective government either in the print media, electronic media, or by way of banners or hoardings in public places during the election period, end of quote. In response to these allegations of improper influence and misuse of public resources, the third respondent submitted that the petitioners had not adduced evidence showing that the particulars of such a sponsorship and that in any case, it is the mandate of the Presidential Delivery Unit to enhance accountability of a government to its citizens by availing information relating to the ongoing projects. We note in the above regard that the first petitioner has not attached any material evidence to support his proposition. That being the case, we are unable to make any determination on this issue of lack of material particulars. Furthermore, the third respondent submitted that the question whether he was allegedly sponsoring the advertisement of the government's achievement in the print and electronic media is pending at the High Court in the case of Apollo Mboya versus the Attorney General and others, and Jack Munjalo and others versus the Attorney General under the Independent Electoral and Boundaries Commission. The petitioners did not contest this averment, and in this regard, we have previously held that we can not adjudicate on an issue which is still the subject matter of judicial determination at the High Court. Reference in this respect is made to the advisory opinion this court gave in the case of, in the matter of Independent Electoral and Boundaries Commission in 2011. I don't have to read the quotation which states that the Supreme Court cannot adjudicate on a matter which is square and pending before the High Court. Further to the above finding, we also note that the petitioner's further contention that the first respondent failed to act on the third respondent's alleged violation of the law by his misuse of public resources. In response, the second respondent stated that he wrote a letter on the 21st of June 2017 informing the Director of Public Prosecutions about the alleged misconduct of the third respondent. The said letter is attached to the affidavit sworn by Wafula Chebukati, which the details of which letter we have quoted. We note further that from considering the contents of the above letter and contrary to the submissions by the first and second respondents, the above letter did not apply to the holder of the office of presidency, in which category the third respondent falls. Furthermore, we note that Section 14.3 of the Election Offences Act, which provides for the Commission's enforcement powers, does not apply to the person holding the office of president. The section we have quoted there in verbatim. Having that in mind and fortified by our observation that the interpretation of Section 14 of the Election Offences Act is a live matter before the High Court, we are unable to address our minds into an allegation that touches on this section. That is the end of that allegation. We are unable to deal with that in the absence of any evidence. We further note in paragraph 34 of his said affidavit that Raila also claimed that while campaigning in Makueni County, on 2nd August 2017, President Uhuru Kenyatta threatened chiefs in the area with dire consequences if he won for failure to campaign for him. That such an action also goes against Article 81E2 of the Constitution, which outlaws intimidation in the electioneering process. In proof of this assertion, the petitioners have attached transcripts of video evidence in the supplementary affidavit sworn by Ogila Karani, detailing the alleged offending words spoken by the third respondent. In response, the third respondent relies on an affidavit sworn by Dr. Karanja Kibicho, who affirms that the Principal Secretary, Ministry of Interior and the Coordination of National Government, he received information to the effect that some chiefs in Makueni, whose names also were provided in the said affidavit, were unlawfully using their positions and the government issued motorcycles to campaign for the petitioners. He therefore reported the same to the third respondent, who warned the chiefs in that area not to take any political position nor use public resources to campaign for anyone. According to Dr. Kibicho, it is against that background that the third respondent uttered the words, uttered the remarks now banned by the petitioners. In the above context, Section 10 of the Election Offences Act is also relevant. We have quoted the full section. What then is the meaning of undue influence in the context of electoral malpractices, and particularly as used under Section 10 above? In India, the meaning of undue influence is found in Section 171C of the Penal Code, which defines the offense of undue influence in that country. Though the wording of the Indian Penal Code quoted above is materially different from Section 10 of the Elections Act, the meaning injected into the above legal provision shows its applicability to the Kenyan context. The Supreme Court of India, in the consolidated case of Charan Lalal versus Gilani and others, thus explicitly stated that the test was whether there was an interference or an attempted interference with the free exercise of the electoral right. Similarly, Section 10 above, whose marginal note is undue influence, forbids any impediment of a person's exercise of the electoral right. In India, the electoral right of an elector is defined under Section 171AB of the Indian Penal Code as the right of a person to stand or not to stand, or to withdraw from being a candidate, or to vote, or refrain from voting at an election. This is comparable with the Article 38(3) of our Constitution, which confers certain political rights on every citizen without any restrictions, including the right to vote by a secret ballot in an election. The above case of India laid down distinction between mere canvassing for votes and the acts of undue influence. In so doing, the Supreme Court of India pronounced itself in the following manner, and I quote, "If the mere act of canvassing in favor of one candidate as against another were to amount to undue influence, the very process of democratic election shall have been stifled, because the right to canvass support for a candidate is as much important as the right to vote for a candidate of one's choice. Therefore, in order that the offense of undue influence can be said to have been made out within the meaning of Section 171C of the Penal Code, something more than the mere act of canvassing for a candidate must be shown to have been done by the offender. That something more may, for example, be in the nature of a threat of an injury to a candidate or a voter, as is stated in the subsection 2A of Section 171C of the Penal Code, or may consist of inducing a belief of divine displeasure in the mind of a candidate or a voter, as is stated in subsection 2. The act allegedly as constituting undue influence must be in the nature of pressure or tyranny on the mind of the candidate or the voter. It is not possible to enumerate exhaustively the diverse categories of acts which fall within the definition of undue influence. It is enough for our purpose to say that of one thing there can be no doubt: the mere act of canvassing for a candidate cannot amount to undue influence within the meaning of Section 171 1C of the Penal Code, end of quote. The Supreme Court of India also held that the language used in the definition of undue influence implies that an offense of undue influence would be held to have been committed if the elector, having made up his mind to cast a vote for a particular candidate, does not do so because of the act of the offense. And this can only be if he is under the threat of or fear of some adverse consequences. Wherever any threat of adverse consequences is given, it will tend to divert the elector from freely exercising his electoral right by voting for the candidate chosen by him for the purpose. But in cases where the only act done is for the purpose of convincing the voter that a particular candidate is not the proper candidate to whom the vote should be given, that act cannot be held to be one which interferes with the free exercise of the electoral right, end of quote. The test of undue influence is therefore whether the third respondent's conduct, if satisfactorily proved, created in the an impression in the mind of a voter that adverse consequences would follow as a result of their exercise of their political choices. In applying that test, we cannot, however, ignore the disposition of Dr. Kibicho, who impugned the alleged non-impartiality on the part of the two chiefs, who are public servants. Thus, the third respondent's statement above must also be tested against the testimony of Dr. Kibicho, which evidence has not been controverted. In the above context, therefore, as a case been made out against the third respondent for the commission of the offense of undue influence within the required standard of proof, have the petitioners dispelled the third respondent's position that he was merely giving a directive that it was against the law for a public officer to openly take political positions in support of one candidate against the other? In this context, words alone, without any other demonstrable evidence, are not sufficient to enable this court to make conclusive finding on this issue. Further, we note that from the evidence of Dr. Kibicho explaining the context within which the third respondent uttered the said words remain undisputed. Consequently, after carefully considering the evidence before us, we hold that the petitioners have not proved their case on this issue as required, the required standard. The petitioners further alleged that the third respondent and the deputy president, being contestants in the presidential election, are guilty of corruptly influencing voters in the lead up to the 8th August 2017 general election by paying reparations to victims of 2007 post-election violence in various parts of the country, and used the platform to canvass for votes for personal political gain in the said electoral areas, contrary to the Election Offences Act. In proof of this assertion, the petitioners rely on the affidavit of Ms. Ogla Karani, who attaches a transcription of the third respondent's speech during his tour of Kisii and Nyamira counties during the campaign period. In response, the third respondent relied on the affidavit sworn by Dr. Kibicho, aforesaid, who stated that there is a National Consultative Coordination Committee which is tasked with the obligation to manage the internally displaced persons' affairs on behalf of the government. That any such sums are approved by Parliament and released by the committee into the beneficiary's account, and the third respondent is not involved in that matter at all. We have perused the attached video transcript, which is the form of interview conducted by one of the local news reporting station, We note that the transcript does not contain a satisfactory basis or convincing evidence to the effect that the third respondent acted in any inappropriate manner with regard to the release of the funds for the IDPs. The first petitioner's further complaint on illegalities is that the President Uhuru Kenyatta engaged cabinet secretaries who openly abused their position and used state resources in actively soliciting votes for him. Referring to Article 152(4)(a) of the Constitution, the petitioner submitted that that every cabinet secretary swears to or affirms to have obedience to the Constitution of Kenya and ought therefore to be impartial in political contests as is required under the Constitution. In a supplementary affidavit sworn by Olga Karani, the petitioners list various incidences in which they claim that the cabinet secretaries campaigned for the third respondent. At paragraph 10 of the said affidavit, the deponent affirms that Joe Mucheru, the cabinet secretary in charge of information, communication, and technology, at an interview conducted by a local television station, he stated that he was at liberty to campaign for the third respondent because no law barred him from doing so. Other cabinet secretaries also mentioned in Karani's affidavit include Eugene Wamarwa, Mwangi Kiunjuri, and Najib Balala. The petitioners in their submissions on these issues brought to the attention of the court what they consider to be an inconsistency in the law, and in this respect, they urge the court to declare Section 23 of the Leadership and Integrity Act to be unconstitutional. In that regard, we have quoted the full section. The petitioner submitted that since cabinet secretaries are state officers, they ought to be impartial, but that Section 23 above gives them leeway for impartiality. The third respondent contested that submission and urges the court to disregard it, since the issue of unconstitutionality was not pleaded in the petition, but was only introduced as an argument in the petitioner's oral submissions. The third respondent also urges that the Supreme Court, in exercise of its exclusive original jurisdiction, cannot adjudicate on the unconstitutionality of an act of Parliament, since that is a matter within the domain of the High Court in exercise of its jurisdiction under Article 165(3)(d) of the Constitution. In addressing the above issue, we note that in rendering our advisory opinion, we also say that we cannot deal with a matter. No, well, I will read that again. In addressing the above issue, we note that in rendering an advisory opinion in the matter of the Interim Independent Electoral Commission, this court stated at paragraph 43, and I quote, quite clearly the High Court has been entrusted with the mandate to interpret the Constitution. This empowerment by itself, however, does not confer upon the High Court an exclusive jurisdiction, for by the appellate process, both the Court of Appeal and the Supreme Court are equally empowered to interpret the Constitution, certainly in respect of matters resolved at the first instance by the High Court. And while the advisory opinion jurisdiction is exclusively entrusted to the Supreme Court, the Constitution does not provide that this court, while rendering an opinion, may not interpret the Constitution. Indeed, interpretation of the Constitution stands to be conducted for different purposes and at different stages by a vast array of constitutional organs. So, for instance, the State Law Office, in advising government ministries, is entitled to interpret the Constitution as may be necessary, and the several independent commissions under the Constitution are similarly entitled to interpret the Constitution as part of the performance of their respective mandates. The Supreme Court 2, for purposes of rendering an advisory opinion, may take its position as guided by its own interpretation of the Constitution. Only where litigation takes place entailing issues of constitutional interpretation must the matter come in the first place before the High Court, with the effect that interpretation of the Constitution by both the Court of Appeal and the Supreme Court will have been limited to the appellate process. End of quote. It is not in doubt, therefore, that the Supreme Court may, in exercise of its jurisdiction, such as this, interpret the Constitution, and in so doing, where the need requires, declare an offending provision of the law to be unconstitutional. Such is a natural consequence of any legal reasoning if the court were to maintain its fidelity to the law. Indeed, in the case of SK Macharia versus KCB, the court declared Section 14 of the Supreme Court Act to be unconstitutional. However, the present scenario is peculiar in the sense that the petitioners did not, at the very first instance, through their pleadings, indicate their intentions to declare Section 23 of the Section 23 unconstitutional. The rule of thumb has always been that parties must be bound by their pleadings, and especially in a case such as this, where the petitioner is asking the court to address its mind to the possible unconstitutionality of a legal provision. For proper consideration, therefore, and especially in order to do justice to both the parties and the greater public interest, we cannot afford to lock our eyes to the disadvantage placed upon the third respondent, especially who had no benefit to bring his mind, to bring his thoughts into this cause. In the circumstances, we are unable to find that Section 23 is unconstitutional. Let the matter be addressed in the right proceedings, in the right circumstances. Irregularities. Apart from the outright non-compliance with the electoral law, the petitioners also claimed that the presidential election was marred by many irregularities and the cumulative effect of which fundamentally and negatively impacted on the integrity of the election. The most serious of the irregularities alleged by the petitioners was that many of the prescribed forms 34A, 34B, and 34C that were used in the election had no security features. Other such forms had different layouts and security features. I don't have to read all that. We have considered the security features. The prominent one coming out of this is that some of these forms did not have those security features, whereas the information we were given was that they were all printed by the same printer and they should have had those security features. We disagree with the council that this is not in the Act and that it was as a result of abundance of caution taken by IEBC. If that was the case, then all the forms should have the features, the security features that IEBC itself devised, and there is no reasonable explanation given why some should not have and some should have. That is the conclusion we have reached. So we have also considered that there are some, the report which was tabled, the scrutiny report, shows that some forms that were availed were carbon copies, others were the original forms 34A, but did not bear those, the IEBC stamp. Other forms were stamped and scanned, while others were not, and they were photocopies. We have considered all those, the report that was availed, but what comes out is that from the report, the scrutiny report indicates that out of a random examination of 4,299 forms 34A, 481 were carbon copies, but they were signed. 157 were carbon copies, which were not stamped. 269 were original copies that were not signed. 26 of the forms were stamped. And some were not signed by the agents as required, and there was no explanation given as to why the agents did not sign, or they were, why they were not given to sign. Submitting on these findings, Mr. Orengo, for the petitioners, contended that the report had proved beyond reasonable doubt that the election process was shambolic. According to counsel, from 34C, which was used to announce the presidential results, had no security features, and hence the authenticity of the results, as announced in Form 34C, could not be guaranteed. Counsel further contended that in totality, the number of votes affected is more than 90 constituencies. In more than 90 constituencies, as a consequence of these irregularities, could be as high as 5 million. Counsel submitted that a random sampling of the Forms 34A depicts numerous irregularities, those ones which I've already enumerated. In response, the respondents were categorical that most of the forms met the standard required features. They stated that the petitioners had failed to demonstrate that any of the figures in the forms were inconsistent with what was announced. Further, that the format of the forms was undisturbed. I'm trying to skip the parts which details of which I've explained. As we have noted that out of 291 forms, 56 from that random sample, 56 did not have the watermark features, while that one did not bear the serial numbers. And a further 5 were not signed at all. And the 2 were only stamped by the returning officers, but not, were stamped by the returning officers, but not signed. In addition, a further 32 forms were not signed by the agents. The above indices are a single route, since they are indices where accountability and transparency of the forms are in question. The court also notes that in our affidavit, Immaculate Kasaiti, director of the first respondent, stated, and we have quoted in extenso the averments of Kasaiti, where she categorically states that all these forms had the features that were given by IBC to the printers.